So welcome to this recording with the OASIS Work Group, which is a subdivision of the OASIS Helpers Group. Today we're going to walk through the counts. There are 3 of them on the indictment, and we're going to cover each one and the facts listed by the government under each. We invite you to freeze your screen and read this disclaimer, if you will. This is not intended to constitute legal advice. It is instead for information and education only. The grand jury returned an indictment against Mike DaCorta with 3 counts. As we will soon discover, conviction on count 2 first required a conviction on count 1. Listed here are the 3 counts: a conspiracy to commit wire fraud and mail fraud in violation of Title 18, Section 1349, attempted conspiracy. Count 2 was illegal monetary transaction in violation of Title 18's United States Code, Section 1757, which is engaging in monetary transactions in property derived from specified unlawful activity. That relates back to count 1, where the specified unlawful activity is identified. And then count 3, false and fraudulent statement on income tax return in violation of Title 26, United States Code, Section 7206(1), which is a declaration under penalties of perjury. So those are the 3 counts under which Mike was indicted. Count 1 refers to Title 18, Section 1349, but Section 1349 refers to any offense under Chapter 63. So it's just a general reference. So we need to see which of the sections actually define a penalty. Sections 1341 and Section 1343 were the only 2 sections referenced in the indictment. So let's see what they say. But before we do, let's remember that every cause of action has specific elements, all of which must have been done in order for the defendant to be convicted of the crime they're accused of, and the charge of fraud has 6 elements. Now, the indictment states that Mike DaCorta devised a scheme and artifice to defraud in violation of sections 1343. Notice the words scheme and artifice to defraud. And it said that whoever devises any scheme or artifice to defraud and transmits any writings or other forms of communication for the purpose of executing that scheme shall be fined, imprisoned, or both. Okay, so these transmissions generally are electronic. They take place by wire, radio, television, things like that. Any writings intended to promote the scheme or artifice to defraud. Now, Part B of the indictment states that Mike also devised a scheme or artifice to defraud in violation of Section 1341. Section 1341 is similar to Section 1343, except that the means of communication is through the post office instead of by wire, telephone, etc., or other electronic means. A conviction in violation of Sections 1343 and 1341 each carries a potential fine and imprisonment of up to 20 years. Now, you may have noticed that we came across this phrase, scheme or artifice to defraud, in each section Mike was accused of violating. Because terms and phrases in law may be given special meanings, it's always important to find out what the definition of them is in any statute you're concerned with. For example, a statute may be written to say that, quote, for the purpose of this statute, the word apple refers to the vegetable commonly known as a tomato, close quote. If you don't know that by reading the definition, it might be really confusing to read about violations relating to apples when they really only refer to tomatoes. For our purposes, in Chapter 63, and thus the sections we've just read, the term scheme or artifice to defraud, as defined, includes a scheme or artifice to deprive another of the intangible right to honest services. So the bottom line is that Mike was accused of devising a scheme or artifice to deprive others of honest services, and of doing so by means of both electronic and postal communications. When you boil it all down, that's what it says. Now, back to the elements again. The elements for a cause of action for fraud. It's important to remember that even if Mike did devise schemes or artifices and make false statements, and even if he consciously intended them to cause others to act on them, unless someone was actually harmed by doing so, the sixth element of the cause of action was not met. So he could not or should not be lawfully convicted of the crimes that he was accused of. If you haven't done so yet, make a note of these six elements upon which a conviction for fraud depends. So the prosecution listed 13 facts in count one of the indictment, and ideally each of them will match up with one or more of the six elements in a cause of fraud. So our group is going to play a little game of mix and match the elements to these 13 facts offered in the indictment under count one. Ideally, the plaintiff, the government, will use each fact to illustrate how one or more of the elements of fraud were made manifest in Mike DaCorta's scheme to defraud. The facts are lettered from A to M under paragraph 14 of the indictment, which describes activities alleged to have happened under count one in violation of 18 U.S.C. section 1349. So let's begin. The manner and means by which the defendant and his co-conspirators sought to accomplish the objects and purpose of the conspiracy included, among others, the following. A, it was a part of the conspiracy that conspirators would and did create both domestic and offshore entities and open bank accounts in the names of said entities to facilitate the scheme. Jason, in your opinion, which of the six elements does this match up to, if any?
I can't find any that this matches up to.
John or Joe, do you agree with Jason? We accept these facts as true as represented, and we're going to test to see if it matches. If it's true, then it needs to match one of the six elements that they're trying to prove with these fact allegations. So Jason says it doesn't match any of them. Joe, what do you think?
Yeah, I don't think it's applicable to any of the six elements.
I agree with Jason and with Joe. It's certainly not illegal to create domestic or offshore entities. Many companies do one or both. So I can't see how this fact relates to any of the elements constituting fraud. So, fact B. It was further a part of the conspiracy that conspirators would and did make false and fraudulent representations to victim investors and potential investors in promoting one of the conspirators as an experienced forex trader with a record of success in order to persuade them to transmit their investment funds to Oasis Management LLC to be traded in the forex market. If this were true, which of the six elements would it apply to?
For me, it would be one, because the defendant makes a false statement there. If this statement here is true, that would be making the defendant making a false statement. Number two, the false statement concerns a fact at the heart of the plaintiff's damages. Fact number four, defendant intended the plaintiff to act in reliance on a false statement. And number five, the plaintiff reasonably relied on a statement and acted upon it.
I agree with that assessment.
Okay.
If it were true.
Assuming these are true and they apply to elements 1 through 5, what would the government have to prove to the jury that elements 1 through 5 were in fact offended?
Well,
What do they have to prove that this?
Yeah, that he wasn't an experienced forex trader. That's the one.
Okay, so they have to prove that he was not an experienced forex trader with a record of success.
Right.
Okay. I agree. C, the conspirators would and did make material omissions and conceal from victim investors and potential investors that one of the conspirators had been permanently banned from registering with the CFTC and was prohibited from soliciting U.S. residents to trade in Forex and from trading Forex for U.S. residents in any capacity. Jason, again, if this were true.
This would be where the defendant is clearly making a false statement. Actually, I don't know if it's a false statement or the lack of a statement by not telling, by the concealing or the omission of what he's got there. So it would be not making the plaintiff aware of.
So it's kind of a false statement by omission, in effect.
Correct.
Okay, it's the absence of one. So,
Yes.
Joe, what would they have to prove to the jury to make this a fact upon which they would convict?
Well, they would have to show whatever document shows that he was banned from registering with the CFTC and was prohibited from soliciting U.S. residents to trade in Forex. That's what
Jason, anything more than that?
Yeah, I feel like that there needs to be some regulatory statute of who's eligible and who's not eligible to have to register with the CFTC.
So they'd have to prove that he was required to be registered. Otherwise, the defense could say, well, fine, he was permanently banned, but he didn't have to be registered in the first place.
Correct.
Yes.
Conspirators would and did make false and fraudulent representations to victim investors and potential investors, including but not limited to that. 1, conspirators did not charge any fees or commissions. 2, investors were guaranteed a minimum 12% per year return on their investments. 3, conspirators had never had a month when they had lost money on Forex trades. 4, interest and principal payments made to investors were funded by profitable Forex trading. And 5, conspirators owned other assets sufficient to repay investors' principal investments. And finally, 6, an investment with conspirators was safe and without risk. Which one does this particularly apply to? Joe?
It was I got 1, 2, 3, 4, and 5, 1 through 5. If
I
it was
agree.
true, defendant makes a false statement. The false statement concerns a fact at the heart of the plaintiff damage and so on.
Yeah, the key is number 1 there, right? Conspirators did not charge any fees or commissions.
I agree, John. I think it boils down to number 1. They make a false and fraudulent representation and then it just, it lists 6 different things that all represent false statements. So I think it just comes down to 1. Jason, do you agree?
I agree.
Okay.
E, conspirators would and did encourage and cause victim investors to transmit funds by interstate wire transmissions and the United States mail and private and commercial interstate carriers to Oasis Management LLC to be traded in the Forex market. Jason, what do you think about this one?
I think this is kind of a non-issue because that would have been a motive. That would have been a motive business you had to do that for the motive business. It wasn't no false statements being made because that's the way it would have to be done.
Correct. I agree. 100%.
Yeah. So this is a non-starter. It doesn't apply to any of the 6 elements, right?
Right.
Yes.
Yeah. And I think that the only thing to really note here is it's all of it says at the very end. It says to be traded in Forex market, and we all know that all the funds weren't in the Forex market.
They would have to prove, but even if they were, even if this were entirely true, it still doesn't indicate any sort of falseness in the making of a false statement.
No falseness, and certainly number 6.
Certainly not number 6. There's no damages here, right?
Yep.
Conspirators would and did use funds transmitted by the victim investors for Forex trading to 1, make Ponzi-style payments to victim investors. There's a footnote on this from from the indictment, it says that a Ponzi scheme was a fraudulent investment program in which funds paid in by later investors are used to pay out non-existent phantom, quote unquote, profits to earlier investors, thus creating the illusion that the fraudulent investment program is a successful profit-generating enterprise, which in turn attracts new investment funds that are used to sustain the fraudulent program. So they're saying here that funds transmitted for Forex trading were for the making of Ponzi-style payments to victim investors. Number two, to pay expenses associated with perpetrating the scheme. And number three, fund their lifestyles and otherwise for their personal enrichment. So which of the six elements would apply in this particular case if this were true?
Possibly two.
The false statement concerned a fact at the heart of the plaintiff's damages, yes. And I would say number six as well. That if this were all true, that the plaintiff suffered damages by relying on the false statements.
And then, hey, important part about all of that is that term and definition right there for the Ponzi.
Mm-hmm.
And the reason I want to say that and bring that up is there was Forex trading going on, and then there was a clear sign of all that going on. There were also other incomes coming into the company where they were actually generating an income through rents of properties and stuff like that, and transaction fees. So the Ponzi scheme definition there is something that we ought to pay attention to in future discussions.
We definitely should.
Yeah.
If this is a game of golf, we've just teed off on this one, and we're going to get halfway down the fairway if we start getting into the evidence already.
Correct.
Yeah,
okay, the conspirators would and did secure broker-dealer licenses from offshore regulatory entities to create the appearance that they could generate even greater earnings by facilitating Forex trading. Anything wrong with that?
I think it's a non-starter.
Non-starter.
I
don't
agree.
see anything applying to it.
Nothing wrong with that.
No, this is like Jason said
Something
earlier.
to do business.
Yeah.
Conspirators would and did solicit victim investors to make loans to OIG, evidenced by promissory notes, purportedly to enable OIG to facilitate a larger volume of Forex trades and thereby generate greater earnings. Anything wrong with that one?
No, same thing.
I think it's a non-starter too. I don't see
This is the
any of
business.
those elements applying to this.
I agree. No elements apply to that. Conspirators would and did develop and administer a back office operation, that is a secure website that falsely and fraudulently depicted victim investors' account balances and earnings in order to convince victim investors that their principal balances were safe and their investments were performing. If this was true, and the website did actually present false and fraudulent balances, what would apply?
Definitely number one.
Definitely number one.
Number
I
two.
think probably through 5 on this one.
Yeah. Yep, 1 through 5.
I would agree. Conspirators would and did encourage and cause victim investors to, one, transmit funds via interstate wire transmissions and the U.S. mail and private commercial interstate carriers to Oasis Management, and or to OIG via a third-party fund administrator purportedly to serve as collateral for Forex trading activity, and two, access a back office website and monitor supposed activity in their accounts, including daily earnings, principal balances, and referral fees. If this were true.
Okay, number one, transmit funds. I mean, that, again, I don't think that's the issue. Transmit funds, if it's true, is not doesn't hit any of those 6. It's number 2, right? If that was true, then that relates to the previous one, right? Then it would be 1 through 5.
Well, it certainly is 5, John. I think you hit it spot on there. It is number 2. I don't think that number 1 is necessarily anything illegal. It's got to be put in context for it to become illegal. Obviously, people do interstate wire transfers and transmissions and mail and everything else legally. But if they are accessing a website and it's fraudulent, And actually, the way it's stated here, that they were accessing a back office website monitoring supposed activity.
Those activity, yeah,
You have to rely upon the word supposed. If it was
correct.
supposed, then it would be fraudulent, right?
Yeah.
Okay. So then, in that case, the plaintiff reasonably relied on the statements and acted upon it would be number 5. And you could say it was number 1, it was making a false statement and so forth.
Yeah.
Anything else? Okay.
No.
Conspirators would and did use funds loaned by victim investors to 1, conduct trades via an offshore broker in the Forex market, which trades resulted in catastrophic losses. 2, did and make Ponzi-style payments to victim investors. 3, pay expenses associated with perpetuating the scheme. And 4, purchase $1 million residential properties, high-end vehicles, gold, silver, and other liquid assets to fund a lavish lifestyle for conspirators, their family members and friends, and otherwise for their personal enrichment. Taken as a whole, if this were all true, which elements apply primarily?
I believe this hits our number 6.
I agree.
Yep.
This hits number 6. Plaintiffs suffered damages by relying on false statements. Conspirators would and did conceal the Forex trading losses from victim investors, including by omitting any mention of said losses from the back office website in an effort to perpetuate the scheme. If this were true, does it matter? And if it does, which of the elements would apply?
Again,
This
it's
one
omission.
It would be a number 1,
Number 1.
a 2, false statements concerning the fact of the heart of the plaintiff's damage. Number 3, defendant knew the statement was false when they were making it. And number 4, defendant intended the plaintiff to act in reliance on the false statement.
Let me ask you this, Jason. Were the Forex trading losses any of the business of investors?
No, because all of the investors were paid through spread fees generated from the trades, not the trades themselves.
Or from other investments?
Or other investments, houses and real estate and all that.
So the
So-
trading losses or trading gains.
One before it talks about the $1 million homes. Those were assets of the company. So once again, that all goes into the barrel of everything here is talking about specifically Forex trading. It's not actually talking about the whole company.
Right. Not only that,
The losses went to the
the losses and the gains only applied to the 3 partners. They had no relevance to the investors. They could not have suffered losses themselves or damages pertinent to number 6
Right.
simply because the company had losses. So I would say this is a non-starter.
Yes, I agree.
Agree.
You convinced, Jason?
I am convinced, most definitely.
Very good. Finally, conspirators would and did misrepresent, hide, and conceal, and cause to be misrepresented, hidden, and concealed the purpose of acts performed in furtherance of the conspiracy. If this were true, which of the elements for a fraud apply? If this were true. If they were misrepresenting, hiding, concealing, misrepresenting, causing that to happen for the purpose of a conspiracy, which would apply?
If it were true, I'd say 1 through 4.
Okay, let me ask you this: what does the government have to prove to make this true? To make this a valid, actionable element for a cause of action in fraud?
That they have to prove that it was indeed misrepresented and conceal the purpose of all the statements and to help aid in the conspiracy. They'd have to prove it.
Yes, and they'd have to prove that it was a conspiracy as well.
Right.
Very good. Okay. This is count 2 in the indictment, and it says that Michael J. DaCorta did knowingly engage in an attempt to engage in a monetary transaction affecting interstate and foreign commerce in criminally derived property of a value greater than $10,000, such property having been derived from specified unlawful activity that is wire fraud in violation of 18 U.S.C. section 1343 and mail fraud in violation of 18 U.S.C. section 1341, in that defendant caused $653,293.67 to be sent via an electronic wire from the Citibank account ending in 0764 in the name of Mainstream Fund Services to the Synovus Bank account ending in 3473 in the name of Berlin Patton Ebling LLC in Sarasota, Florida, in connection with his purchase of the personal residence located at 13318 Lost Key Place, Sarasota, Florida, in violation of 18 U.S.C. section 17 of 1957. As you can see, this depends upon a conviction of count one. It's derived from property that came from criminally derived property. Well, they have to prove count one to prove that any property was criminally derived, for starters. And then next, that specifically this relates to the property at 13318 Lost Key Place. So was that criminally derived? Because if it wasn't, then there was no illegal monetary transaction.
I agree.
Count three. On or about October 8th, 2018, in the Middle District of Florida and elsewhere, the defendant, Michael J. DaCorta, did willfully make and to subscribe and cause to be made and subscribed a 2017 U.S. individual income tax return, IRS Form 1040, which was verified by a written declaration that it was made under the penalties of perjury, and which he did not believe to be true and correct as to every material matter, in that the return reported an amount of total income at line 22, which the defendant then and there knew and believed understated his total income in violation of Title 26, United States Code, Section 7206(1) and 18 U.S.C. Section 2. So what have they got to prove to make this convictable, actionable element in the cause of action?
That Mike DaCorta made a false statement on his tax returns.
He lied on his tax returns.
Say again, John?
He lied on his tax returns.
What's the most important part of this?
Lied?
Which he did not believe to be true and correct.
Yeah, correct.
Which the defendant then and there knew and believed understated his total income. They have to prove that he knew these things.
And at that point, there was a tax preparer that performed all of them taxes. There was a tax preparer that prepared his taxes for him.
That's correct. There was. He hired a CPA for that purpose. So I would think it would be a very high hurdle to know a man's mind when he hires a professional specifically accredited and licensed to do the work, and then simply signs off, as everyone does, on the CPA's work, that he alternatively actually knew that the information on line 22 was incorrect, and that he believed and knew that it was an understatement of his income. But that's what they had to prove.
I got to add a little
It's a
piece
high
of,
hurdle.
at the very end. Whenever I ask people to ask this question every year, whenever you go into your CPA and they say, sign here, and they got the little arrows at the boxes. Do you go through line item by line item of your tax returns before you sign that and send it off to the IRS? Are you just happy there with a smile that says you don't owe nothing? Or the amount you owe is a lot less than what you thought you was going to owe?
Yep. All right, fellas, I think that wraps it for tonight, unless you've got some residual comments you'd like to make. I think we're done. Anybody got a final word?
Actually, yeah.
Ready for,
I have a question. So is it the 13 sections that we went over? Is it the fact that 1 through 6 was covered all or in part of those 13? Does that like make it viable, or does it have to be for every one of those subsections that we went
Each
through?
one of these sections, A through M, can apply to one or more of the elements in the cause of action. And we've now gone through it, and we found that there's at least one that applies to all 6 of the elements. Okay. We found that number K, for example, or letter K applied to number 6, the damages. And frequently we found things that applied to 1 through 4, 1 through 5, things like that. Some were irrelevant. But now the government is going to go in and make a case based on these alleged allegations or facts, if you will, and they need to build their case on this. It's very much like they've now given the defense a recipe, and the defense should be able to sit down and look at this and go, okay, this is the element of the cause of action they're going to attack specifically in this way. This is the ingredient, if you will, to make their case. What am I going to do about it? And the next time we do our next video will be on the opening statements, where both the prosecution and the defense attorneys basically describe what kind of cake they're going to bake with the facts and the evidence they're going to present to the jury.
That's good. It's going to be interesting if they follow the recipe, or how do they? This is good that we went through this, because it does lay out. Now we'll see when they do their opening statements.
What we should be looking for.
Yep.
Exactly. And as you go through each witness, you'll be able to map the witnesses to one of these A through M and say, well, they're up there in order to bolster the case for, B, C, and so forth.
Correct.
We'll see if they do. And that's what we'll get further down the fairway toward the green and find out if they've effectively made a convincing argument to support their indictment.
For me, I'm sorry for over talking you at the beginning, John, but I'm really looking forward to the deep dive of the information that the defense had and was readily accessible for them that did not get into the courtroom presented, and the information that the prosecution had that might not be so transparent as they made it out to be. The evidence that the talking points that they made is not quite as it appears sometimes. And I'm looking forward to our deep dive into those things when we get there.
Yep. Yeah.
So very good. All right, gentlemen, thanks so much for giving of your time again, and we'll meet again soon.
Sounds good.
Good
night, guys.
Good night. Good night, everybody.
See you.